Good afternoon, and it's a pleasure to be with all of you. It is hot here in New York City, 90 degrees as I speak here and look out at Midtown. It really does feel like summer, hoping that all of you enjoyed the holiday weekend and had some chance to get out there and do whatever it was that brought you some joy, of course, while remembering those we lost. And with that, I wanted to give you a sense of what we're going to be covering today as a group. And if Kathy, you'd advance the slide, that's great. What you'll see here is an agenda that will cover really the next 45 minutes of our time. And I will kick things off with an update on COVID shortly, as well as a few minutes on where we are in New York State's legislative cycle. We're at the moment where, as of Thursday, the legislature is supposed to pack up and head home for the session, though we shall see, and we'll let you know what is making its way toward that finish line. And then I will turn it over to Rick Weber, who will focus on some particularly important legislation that recently the governor signed into law, the Adult Survivors Act. Thereafter, Delaney Knapp will touch on issues concerning not-for-profit law and LLCs, really interesting stuff there. And then Amelia McLean Robertson will follow Delaney with coverage of the New York State Climate Leadership and Community Protection Act, which is really significant legislation that was signed into law a couple of years ago, but now we're moving all the more into implementation, and we will get caught up through that presentation. So with that, Kathy, if you could advance to the next slide, please. Let me tell you all about where we are with COVID. Unfortunately, the news nationally is not improving. As of the last report that I shared with you, we definitely saw an uptick, though it was more geographically focused on where we find many of you listeners in the Northeast and as well in the Midwest. What we're seeing generally right now is a 21% change in 2 weeks in terms of cases. We know there are some issues in terms of how cases are measured, of course, with far more in-home and antigen testing, but with the best data we have right now, we're seeing a 21% rise. And if you could please advance, Kathy, then let me provide the group with a bit of context. I mentioned that in the Northeast, we were seeing very high concentration, relatively speaking, 2 weeks ago when I last spoke with all of you. What we're seeing now is greater spread. That intensity in the Northeast has abated a bit, and we'll talk about New York in just a moment specifically, but we are seeing more of those darkened colors around the United States, particularly on the West Coast, up the Atlantic coast, and in other corners of the country that were lighter shades in our report just 2 weeks ago. So that's where we're seeing that 21% uptick. It's really across the country in a more evenly distributed way. So what does that mean? If we could go to the next slide, please. Let's focus in particular on New York State, where many of you are, again, tuning in from. Here in New York, we have seen a relative diminishment, actually, from that first snapshot of 2 weeks ago that I shared with you. And what we are seeing is a 14% drop over those 2 weeks, which is significant. And we are also not in a position where there is any new mandate to report to all of you, whether federal, state, or local. We all remain in that space where there are recommendations concerning indoor masking, for instance. So as we enter these summer months, and with any luck, more of our activities are outside, we shall see whether these kinds of rates continue or otherwise what the snapshot will look like in a couple weeks' time. But for now, the good news, relatively speaking at least, is that New York State has seen some improvement since we last checked in here as a group. If you would please advance, Kathy. So just to give you some more data on that 2 week differential, what you will see again at the top line of these two side-by-side charts is the 14% drop across the state. And then you'll see depictions of individual cities and other counties where the numbers are substantial enough that they made this reporting. And thanks to the New York Times, by the way, for all of these data. Let's go to the next slide, please. So I'm going to then shift gears, as I mentioned at the top of this webinar, to talk a bit about the New York State Legislature and where we are at a very important moment. We are looking at the end of the current legislative session in just about 2 weeks, in about 2 days, forgive me. Today is the 31st, and then we go through till June 2nd. And at June 2nd, supposedly the legislators will find their way home. We shall see if anyone is inclined to stick around for an extended session, which happens from time to time. There's a lot of really important stuff that the legislature is working through right now. So let's get to it and talk through what those elements are. So Kathy, if you would please advance the slide. Well, first, a point of context. All of you who have been in New York State have to have heard the name Dick Gottfried, who is a legend of sorts in the legislative space, the longest serving assembly member, having become an assembly member back in 1971. His base has always been here in New York City on the west side of Manhattan. The district boundaries have changed a little bit here and there over the years, but that is where Dick Gottfried has served. And in addition, he has been a vocal advocate for a variety of issues around health, including as the chairperson of the Assembly Health Committee. And he has been an advocate in specific for many years concerning the New York Health Act. And that would bring something akin to a single payer system in New York State. That is not going to get through this legislative session. That much is clear based on the appetite both of the governor as well as those in the legislature. But it is an important moment to recognize just what kind of career of accomplishments Assemblymember Gottfried has made, and to know that there will be some shoes to fill. Why don't we move to the next slide, please? Speaking of this current session and the intersection, of course, with our governor, Governor Hochul has been very vocal around reproductive rights in the wake of what were the leaked documents that came from the Supreme Court concerning what may be, as the Supreme Court concludes its session in the next month, a significant change in the language of Roe v. Wade, and ultimately what types of federal protections there are for reproductive rights. And so many states like New York are stepping in advance in order to provide additional protections at the state level. Of course, that is really a testament to some of the local politics that we see around the country. And in New York State, Governor Hochul has been very vocal that this is the time. The legislature is very much in alignment, and there are several bills that are making their way through. At least one of them will be signed, probably more. And what we also may see out of all of this is a constitutional amendment that will, if it were to move forward, and there are additional steps beyond the legislative session for that to happen, it would enshrine a variety of rights around equity. But again, much more here to come. The key elements for these next few days will be to see what legislation gets its way through the legislature and ultimately on its way to the governor. Let's go to the next slide, please. Other areas that are active in the legislature right now, no surprise, of course, we're seeing movement around gun control policies in the wake of the terrible tragedies both in Buffalo, which in our last broadcast that I was a part of 2 weeks ago, we addressed. And since then, of course, the subsequent tragedy in Uvalde, Texas. And so it would not be surprising at all to see some type of assault weapons language make its way through the legislature and then ultimately to the governor's desk. The governor has indicated an interest in signing such legislation. And then we'll see movement around opioid management as well as alternative therapeutic pathways. The Office of the Medicaid Inspector General is expected to get some enhanced powers. Exactly what that looks like, we have to all wait and see a bit. And then here in New York City, there are some interesting dynamics, of course, in our post 2020 circumstances, there is a major change in terms of how space is being utilized, and that's also the case around New York State and around the country, where core urban centers have a lot of empty hotel space. And so there's discussion underway about possibly converting some of that into affordable housing, utilizing legislation for that purpose. Let's go to the next slide, please. All of this happens within the backdrop of upcoming primaries, which are a major deal, of course, in New York, where first on June 28th, we'll see the governor as well as the lieutenant governor up for primary election. The general will, of course, be later in the fall. And then federal primaries are taking place later this summer on October 23rd. This follows what has been a very complicated path in order to see redistricting following the 2020 census. And one of the really interesting sidebars that has come out of this is that two longtime serving New York members in Congress, Gerald Nadler and Carolyn Maloney, are running against one another in a primary, and one of them will, of course, lose. And so one of them will be concluding a congressional tenure as a result of that primary, barring anything unforeseen. So with that, let me ask Kathy for you please to advance to the next slide. And I thank you all for your time. And now let me introduce Rick Weber, who's here to talk about some of the details of that legislative session in ways that all of you should be paying close attention to, because it's complicated and there's a lot to learn here. Rick comes to us from Syracuse, where he is a member and an experienced litigator, as well as the co-chair of the firm's toxic tort and environmental litigation practice. He has detailed knowledge of the Child Victims Act, which is really germane to the Adult Survivors Act. In many respects, that previous legislation provided the scaffolding for what Governor Hochul just signed into law, and that Rick will bring you up to speed on in terms of its implications for businesses like those listening in here. And with that, Rick, thank you for taking this time, and the floor is yours.
Absolutely. Thanks, Gabriel. Happy to be on this webinar today. As Gabriel said, it's very warm in New York City. It's also warm up here in Syracuse. We expect to get to about 90 at some point in the day. But getting right to it, one of the hallmarks of the legislative session was the passage of the Adult Survivors Act. The closest analog this has is the Child Victims Act that was passed during the Governor Cuomo's tenure, and then that was further extended. The Adult Survivors Act had been put through the legislature before. It had not advanced as far as the governor's desk. This year it advanced, and Governor Hochul signed it. What it does is it creates a one-year revival window for claims of sexual abuse that would otherwise be barred by applicable statutes of limitations. So when you think about a statute of limitations, normally you would think about a standard one-year period for suing someone if they committed an intentional act that caused you harm. You would think of a 3-year period from the date of the event to sue someone if they were negligent somehow in causing the event to occur. So the effective date of this act will be November 24th, 2022 through November 23rd. And as I indicated, it opens this one-year revival window. What that means is that any claim related to the set of delineated sex abuse claims can be revived, even if it was not brought within the applicable statute of limitations period. In this regard, it's similar to the Child Victims Act. The Child Victims Act had a one-year revival window that, due to COVID, was extended to a 2-year revival window. That act generated over 10,000 lawsuits throughout the state of individuals who were claiming to have been abused as minors, 17 and under, as far back as the 1940s. So those claims, as you might imagine, were directed predominantly towards youth-focused organizations, elementary schools, high schools, churches, Boy Scouts. There's no such limitation, natural limitation, involving the current adult survivors Act. This will revive a claim by an adult, age 18 and above, who suffered the requisite sexual abuse at any point in time after turning age 18. And there's no natural restriction on how old these claims can be. The new law, it's important to remember, is not a criminal statute. This doesn't empower district attorneys to go out and prosecute individuals. What it is instead is a civil-focused statute. It opens a window for civil lawsuits in New York State courts where the alleged victims are seeking monetary compensation related to injuries from the alleged sexual abuse. Next slide, please. So what's important to bear in mind, and why this is I think, going to touch every aspect of the business community in New York, is that the new law is not limited to intentional acts of the individual abuser. The alleged victim can pursue claims against third parties, such as employers or business owners or property owners, and can use theories such as negligent hiring, negligent supervision, negligent retention, negligent training of employers or supervisors to pursue such claims. So you can think, if you pause for a moment, on the scope of that. There's no reason why an adult who suffered an abusive act in a health club locker room in the 1990s couldn't now sue that health club provider, the health club operator. There's no reason why an individual who was a junior partner in an accounting firm who suffered abuse at the hands of an older partner at an accounting firm couldn't now sue that accounting firm for the byproducts and the after effects and the injuries resulting from that impact. No reason why a student at a college who was over age 18 who suffered abuse in a dormitory or in a college bar couldn't maintain now civil lawsuits related to that abuse. The law allows recovery for physical, psychological, or other injury or condition resulting from conduct that would constitute a sexual offense or incest. And the list of sexual offenses set forth in the Adult Survivors Act adopts certain offenses that were set forth in the criminal law, specifically in Penal Law 130. So some of these you might have a solid conception of already. Concept of rape, concept of criminal sexual actions, those types of things. The crimes that are incorporated track closely with what was incorporated in the Child Victims Act as well. One of these I want to call your attention to just to show the breadth of what we're talking about. That would be the crime of forcible touching. Next slide, please. So forcible touching is not something that might instinctively resonate resonate with someone who's not a lawyer who doesn't look at these statutes frequently. But forcible touching talks about intentional touching of the sexual or intimate parts of another person for the purpose of degrading or abusing that person, or for the purpose of gratifying the actor's sexual desire. So this is a standard that's far less than the sex crimes that you might see prosecuted. That you're familiar with, right? The terms of rape that involve certain penetration or certain overt sexual acts. This includes the idea of one individual forcibly touching another individual. These could be the groping claims, pinching, grabbing, that sort of thing, without full-on kind of penetrative sex violations and crimes. So the potential for these is very broad indeed. There's no limit on the age of claims that may arise as a result of the new law. That presents a difficulty to lawyers who defend the defendants who are going to be sued in these cases, right? The health clubs, the colleges, conceivably the hotels, the places of business, right? Because there really is an issue of trying to figure out exactly what was happening at the organization, say, in the 1960s, 70s, or 80s. And we will see claims that go back to the 1960s, 70s, and Oftentimes, these businesses or these entities won't have anybody who's still active in the business who has a recollection of the policies and procedures that the business implemented in the 60s, 70s, and 80s. There's also going to be operative questions of whether they were in conformance with the law as it existed at that time, as opposed to the law that might exist today. And the best practices on training employees, right, or supervising a property. Certainly today, best practice at a particular property might mean you have surveillance cameras. Well, in the 1960s and 70s, that may not have been a viable or realistic option due to technology. One of the key things that I think is worth mentioning, though, is if you think you're in a situation where your business or your particular line of business might be a potential defendant, where you can see how you will have claimants that will assert that your business should have been more diligent, it should have better supervised employees, or taken better measures to safeguard the safety of individuals who came on the premises. If you believe your business might fall within that category where individuals will be alleging that, one of the important things to ascertain now before the window opens up is exactly what the scope of your applicable insurance coverage would have been historically over past years. Certainly you can contact us. We can talk a little bit more about that offline if necessary, but what becomes very important and what becomes a frequent problem is that most businesses will renew their insurance policies from year to year, or they'll have a different insurance provider. As the years go on, they've not thought of any reason to retain historical copies of insurance policies or historical correspondence regarding scope of coverage. There is a certain amount of time now before the statute goes into effect where if you could do anything, we would certainly suggest you start researching what insurance company your business may have for literally the preceding 4 or 5 decades. It's going to be, I think, a large issue when these lawsuits start rolling in, and we'll, of course, keep monitoring it. But with that, that's my part of the process. I'll turn it back over to Gabriel.
Thank you so much, Rick, for that really informative presentation. And it's a very complicated set of factors that you've walked the group through, and glad to know that you and others at the firm will be watching this closely and available for questions. And with that, I'm interested, of course, in making sure that Delaney Knapp gets the warm welcome that she deserves, and specific as one of our attorneys out of the Albany office. She is an anchor in our work with not-for-profit and other exempt organizations, really across disciplines, and working with Tom Simcoe and others, very deeply involved in the life cycle of charitable organizations, and that includes contracting and compliance. And today, Delaney is here to talk about a really interesting set of issues involving limited liability corporations and not-for-profits in New York State. So with that, Delaney, the floor is yours, and thank you in advance for walking us all through this really interesting set of issues.
Of course, thanks, Gabe. So what I'm going to be speaking about today are some updates with respect to the use of charitable LLCs in New York State. So most of us are probably familiar with the not-for-profit corporation in terms of a corporate entity in the form, but charitable LLCs have also been used as well, and there's many benefits to this. They're uniquely flexible from a governance perspective, so you can be managed by a corporate member, a sole member, or maybe a board of managers. A board of directors is not required like it would be in a not-for-profit corporation, though a board of managers could run the same way. There's tax flexibility, so LLCs are capable of being taxed as corporations, as partnerships, or as being completely disregarded entirely. They also allow for limitless variations on how ownership is structured and how profits and losses are shared. But despite all these benefits, they have tended to only play a niche role in the nonprofit sector, and that's partially due to some limited guidance in terms of how they would comply and be susceptible to tax exemption under Section 501c3 of the Internal Revenue Code. Next slide, Kathy. So as I mentioned, there's historically been pretty limited guidance. We've known that LLCs could apply using the same exemption form as corporations and other entities like charitable trusts, but there's just not a lot with respect to the instructions. So when applying, a lot of LLCs were just having to kind of figure it out on their own. But most recently in October 2021, the IRS did provide guidance with respect to what would be required for an LLC trying to obtain tax exemption. Now they have to meet the general 501c3 requirements that all other entities would, but there's also specific substantive requirements that have to be included in their articles of organization and operating agreement. Those are submitted as an attachment to the exemption application. And there also has to be a certification within the narrative of the exemption application. Next slide. So with respect to these additional requirements, one of them is specificity around the membership of the LLC. So each member of the LLC must be either an organization described in section 501c3 and exempt from taxation under 501a, or it would need to be a governmental unit or a wholly owned instrumentality of that governmental unit. There also has to be express charitable purposes listed within the articles of organization, as well as express dissolution provisions, mainly that the assets of the dissolving LLC would need to go for 501c3 charitable purposes. There would need to also include Chapter 42 compliance provisions. Those are specific to entities that are classified as private foundations and list the requirements and limitations on those entities. And then with respect to the exemption application, there has to be a certification that the above provisions listed here are consistent with applicable state LLC law and legally enforceable. And that certification is what we're going to come back to in a couple minutes and why it might be problematic. Next slide. So after the IRS released its guidance in October, it requested comments through the beginning of the year, and the New York State Attorney General released the following. It was a letter. This is the key excerpt, though. It stated that where state law, as in New York, does not authorize creation of an LLC for charitable purposes, the IRS should refuse to authorize 501c3 eligibility for LLCs domiciled in that jurisdiction. And the AG here is taking the position that New York law, LLC law, does not allow LLCs to operate for charitable purposes, and therefore, if the IRS receives an exemption application from a New York LLC, it should refuse to grant exemption. Next slide. And so the basis for this position comes from the fact that Section 201 of the Limited Liability Company Law authorizes LLCs to be organized and operated for lawful business purposes. This term business is key. It's defined in the same law as a trade, occupation, profession, or commercial activity. And so the AG is taking the position that this does not include charitable purposes. Next slide. Now, in the past, this really has not been the position of the state, especially the Department of State. Articles of organization have successfully been filed for many years with expressly charitable purposes, including direct references to Internal Revenue Code Section 501c3. Once the IRS guidance came out, we actually did try to amend the articles of organization of one of our clients. We submitted the amendment to the Department of State and received a rejection letter in return. I have a snippet on this slide of the language that we were provided with, noting that limited liability companies may only be used for business purposes and that charitable purposes are unacceptable. Next slide. And so, unfortunately, this leaves us with more questions than answers, some of them being, what does this new interpretation mean for existing New York LLCs that have charitable purposes? Are they considered not validly existing under New York law since they don't have business purposes? Will their activities be viewed as being conducted directly by their members? Or is it only that their charitable 501c3 purposes are void? Next slide. Will the New York State Attorney General attempt to provide answers to the questions, or the Department of State? Is this going to be left up to the courts? And how will the IRS respond? Will they agree with New York's view or rely on its own capacity to interpret federal tax laws? And so we've, in the past, written and published 2 articles on this topic. We are uncertain at this point in time when further guidance will come, but we'll be sure to keep you all updated.
Well, Delaney, thank you.
Sorry, Dave, I do see a question in the chat. So purely from a policy standpoint, any idea why the Attorney General is driving this position? Seems unnecessarily antagonistic. Just curious why they see an issue. So with respect to the AG's comments, they did state that right now, the New York not-for-profit corporation law allows for Attorney General oversight over charitable assets that are held by not-for-profit corporations, but there's not necessarily the same authority or oversight allowed by the Attorney General with respect to charitable LLCs. And so I think that is probably one of the positions that they're taking, but hopefully we'll get more information in the future.
Well, Delaney, thank you for answering that question, as well for providing this really helpful update on limited liability companies. And as you pointed out, more questions than answers at this point, but good to know that you and colleagues in Albany and across the firm are ready to help if organizations encounter roadblocks around these types of issues. And looking forward to having you back in a future instance, Delaney. And with that, let's move to our last speaker for this afternoon. Amelia McLean Robertson is an associate out of our Syracuse office. And Amelia has been working on helping get bond clients positioned relative to New York State's Climate Act, which is big legislation that passed a couple of years back, as I mentioned, but it is now moving into the implementation phases slowly but surely, and we'll get caught up on where things stand along that arc. Before joining Bond, Amelia came from the city of Syracuse's Corporation Counsel's office, where she had a really varied plate of matters that she was involved in, including developing the city's 5G network and lots of hands-on transactions involving the city's property interests. So we're in good hands, and Amelia, please go ahead and guide us through what you know. We look forward to learning.
Well, thank you for that introduction. Yeah, I'm here today to provide a very high-level overview of the CLCPA. Many of you may be familiar with it already. If you're not, you should be, because it is really ambitious legislation. The goal is to decarbonize the economy, reduce emissions, increase renewable sources of energy. So yes, the CLCPA, also known as the Climate Act, it is currently in the public comment period, which I will speak to shortly. Several sectors of the economy are going to be affected. Today, we're going to focus a little bit on transportation, buildings, and electricity or power sources, as those are the 3 that are attributed to the highest level of emissions, greenhouse gases. If we go to the next slide, please. So the CLCPA, by design, sets targets to reduce emissions using 1990 as the baseline. So as you can see, the goal by 2030 is to reduce the emissions by 40%. Increase renewable electricity and power sources 70% by 2030. This is also known as a 70 by 30 goal. And by 2040, have zero carbon electricity. And if we could go to the next slide, please. So on top of the targets for reducing emissions, there's targets to increase renewable energy sources. So these goals increase the amount of offshore wind, 9,000 megawatts by 2035. Solar projects, 6,000 megawatt target by 2025, so that's coming up. By 2030, increasing energy storage. And as you can see, Governor Hochul called to increase the storage limits because we're going to need it, and a lot of money has been budgeted to achieve these energy goals. New power plants, solar panel plants, those types of projects. And one specific detail in the CLCPA regarding just transition, climate justice, particularly with respect to the energy goals. There's a focus on disadvantaged communities and making sure that disadvantaged communities reap a certain percentage of the benefits of the funding and the benefits of the energy sources. So the CLCPA goal is that disadvantaged communities receive 40% of the overall benefits of the spending and these energy goals, and that they receive 35% of the benefits, of the investment. This is significant. The environmental conservation law has a definition for disadvantaged communities, but starting March 9th, we're currently in a 120-day public comment period to determine the actual criteria of how a disadvantaged community will be defined. So while there's a definition, when it comes to the actual implementation of how this money will be sourced in a way that benefits disadvantaged communities, the criteria for what determines a disadvantaged community is still open for public comment. If we could go to the next slide, please. So, as I discussed earlier, the draft scoping plan is what is available to the public for public comment. This scoping plan was created by the Climate Action Council. They've been having meetings over the past year to discuss these different components of the CLCPA, and they have been advised, the Climate Action Council has been advised by certain advisory panels. So there are advisory panels for transportation, energy, land use and local government, waste, and agriculture. So there's been separate subgroups working together to advise the Climate Action Council, who ultimately came up with a draft scoping plan. It is very extensive, provides a lot of different ideas, how to target and achieve different goals. So it's extensive and worth reviewing. It's well organized. For example, how air permitting, gas line permitting, building permitting will be affected. Ideas for how this will be implemented are in the draft scoping plan. And the goal is, and what we help with, is helping clients navigate, the public comment process, to make sure it's a collaborative effort between the business owners, general public, and, the Climate Action Council. Okay, next slide, please. So certain strategies for, as I discussed earlier, for buildings specifically, shifting away from gas power and shifting back to electric power. And I'm going to go into a little more detail in subsequent slides, but electrification of transportation. This will have big impacts for any business in the logistics industry, managing a fleet of current vehicles using fossil fuels. The goal is that everything gets shifted to electric vehicles. Additionally, the plan, and I'm trying to keep this high level, which is difficult because it's so much, but refrigerants. So certain, businesses using equipment requiring refrigerants, disposal of those refrigerants, while that is currently regulated, and a lot of these things are already currently regulated. In order to achieve certain goals, the regulations will change. You know, the DEC will be offering, regulations that will help achieve these targets. So it's going to be kind of a different baseline that's going to be established, especially for applying for permits. Okay, if we can go to the next slide, please. Yeah, so 28% of current GHG emissions get attributed to transportation. The CLCPA plan and envisions 3 million electric passenger vehicles on the roads. Additionally, so shifting transportation to electric is going to be more than a one-state effort. New York, Washington, D.C., and 14 other states signed a memorandum of understanding regarding medium and heavy-duty vehicles to work together collaboratively to help, progress and accelerate the production of these, the entrance of these into the markets, the way to power these. So yeah, this could have, 3 million more electric vehicles, passenger vehicles in New York, plus businesses shifting their fleets to electronic vehicles. It's, it's ambitious. And as far as electricity, as discussed earlier, the 70 by 30 plan, shifting to a 70% renewable energy use, and it's difficult. It's so early at this phase to say how this is going to play out, because the targets exist, but we don't know if the technology or the renewable energy sources will be ready in time to meet the targets. So it's going to be, the businesses, legislature working together to, make this happen. Next slide, please. Yeah, as far as buildings, the biggest shift will be prohibiting gas service to new buildings, and buildings that currently run using gas service, shifting those to electric. So real estate developers are going to essentially be encouraged to comply with shifting to electric, and yeah, no more gas service to buildings. That's probably the biggest change. And next slide, please. Yep. So to wrap it up, public comment period on the CLCPA draft scoping plan ends June 10th. The Climate Action Council did meet on the 26th. There were May 26th, there was discussion about extending the public comment deadline, although we haven't had an announcement yet. And thank you so much.
Well, thank you very much for your presentation, Amelia. We're delighted to have had you, and we're hopeful that overall this was an informative 45 minutes for all of you, as we always intended to be. We look forward to taking your questions, whether now, though I don't see any in the chat, or offline, as you may have them. You can reach any of us by way of the emails that are now on your screen. And of course, reach out by phone, whatever is easy. And we look forward to being with you. Adam will be hosting a week from today. I'll be back in 2 weeks on the 14th. And in the interim, please stay safe above all else out there and enjoy these first glimpses of summer. Looking forward to seeing you soon.